2026, there is no single federal breach notification law that applies across all sectors. Hello everybody and welcome back to Privacy Professional Training. My name is Fumi Owolabi. In today's video, we're going to spend some focus time on state data breach notification laws, which falls under Domain 5 of the CIPP US exam. So I wanted to spend some time on this because I think notification is really important, as are breaches which are becoming far and far more common. This particular topic may seem overwhelming at first because there are many state laws and a lot of variation. What helps is understanding that although details differ, state breach notification laws tend to follow a shared structure. As we go through this discussion today, my goal is to help students become comfortable recognizing what the structure is when it comes to notification and the recurring concepts that appear across states. Rather than trying to hold every state rule in your head at once, it's more helpful to understand how these laws generally work. So for the exam, you have 90 questions, right? The level of detail may differ from question to question, but as long as you understand breach notification, you're going to be in good shape to continue with your studies. Let's talk about why data breach notification is a state level issue. Here in the United States, every single respective state has its own data breach notification statute. Now, these laws developed over time as data incidents became more common and more visible. So you might be familiar with the Equifax breach that happened a number of years ago. That's still talked about in many privacy circles in 2026. Historically, when we look at breaches, we're thinking about laptops being stolen, systems being accessed without the proper authorization. And so states began passing laws ensuring that individuals would be informed when their personal information was exposed. Now, as of 2026, there is no single federal breach notification law that applies across all sectors. Because of this, states have taken different approaches while addressing similar concerns. As a result of this, state breach notification laws tend to look alike in broad outline, but differ in details such as definitions, timelines, and remedies. And we see this across the US state privacy laws in and of themselves. So the core concept I want to talk about today is defining personal information. Now, this is going to come up in every single domain, but state breach notification laws generally begin by defining what constitutes personal information within the state. At a basic level, this often includes an individual's name, full name, combined with, for example, a sensitive identifier like a social security number, which we have in the States, a driver's license number, or a financial account number. And in many states, they go beyond this baseline. In some states, you'll see things like precise geolocation data, you'll see information like medical or health insurance information. So it really does depend on what each respective state defines as personal information. And essentially, personal information is any identifies an individual. And it could include things like certain categories of unique identifiers, online identifiers like an IP address. You might also encounter a situation where information was accessed, but the question becomes whether the data fits within a state's definition of personal information. So if the state doesn't consider it personal information, that's something you've got to take into consideration. For example, a dataset containing only names and email addresses may be treated differently from one that includes passwords or financial details. This is why it is important to look carefully at the specific data elements involved, not just whether data was accessed. And having that preliminary foundation of what constitutes personal data is going to be really useful in those scenarios. The second concept is what counts as a security breach. Not every incident that a business encounters involving data qualifies as a breach under state law. Most state statutes focus on unauthorized access to or acquisition of personal information that compromises the security or confidentiality of the data. This means that for the exam, context matters. For example, an internal error where data is briefly exposed but not accessed may be evaluated differently from an external intrusion. Similarly, accidental loss and malicious access can raise different concerns from state to state. State breach notification laws tend to focus on whether individuals face a real risk because of the incident, not simply whether something went wrong internally within the organization. So being able to make the distinction on whether or not it's really going to affect the consumer is going to be important while you study. We also need to take a look at the risk of harm and encryption. Many states allow some form of risk of harm analysis. This means an organization or a business or a company may assess whether the incident is likely to result in the misuse of the information. If the risk is minimal, notification may not be required. So I think a really important theme here that we can see across domains is we look at privacy from a risk perspective, which is why you can see that there's a distinction between ordinary personal data and then sensitive data, and in other geographies, special categories of personal data. So let's take a look at encryption. Encryption is frequently part of this analysis. If personal information is encrypted and the encryption key remains secure, many states treat this particular risk differently. This doesn't eliminate the concern, but it often affects whether notice is required. While you study, you might see examples involving stolen devices, lost media, or compromised systems where encryption plays a central role in the analysis. Another key concept is who receives notice. State breach notification laws often identify more than one recipient of notice. Affected individuals are usually the primary audience. However, many states also require notice to regulators under certain conditions. This may include the state attorney general, consumer protection agencies, or credit reporting agencies when a large number of people are affected. For instance, a breach affecting a small number of residents may involve only individual notice, while a larger incident may trigger regulatory notification as well. The scope of the incident often influences who must be notified, so pay close attention to what the question is asking you in this respect. Another concept in relation to breach notification is the timing of the notification. Timing requirements vary significantly across states. Some laws require notice without unreasonable delay. Others specify firm timelines, such as 30, 45, or 60 days. Through your studies, you may encounter situations where notification is delayed due to ongoing investigations. Some laws allow limited delay if notification would interfere with law enforcement efforts. At the same time, notification is generally expected to occur within a reasonable period. Open-ended delay is not typically supported. So you're taking your review into a risk-based approach. The definition of reasonable is very broad, so you're going to have to make that determination based on the facts of the question. States also regulate how notice is provided. Some of the common methods are written notice, electronic notice, or a substitute notice such as a website posting or media announcements. Substitute notices may be used when direct notice is impractical. This can happen when contact information is missing or costs would be excessive. Some key notes in scenarios involve outdated records or incomplete contact details, which often raise questions about notice methodology. The content of the notice is also scrutinized by state breach notification laws. Many state laws describe what information must appear in a breach notice. This often includes a general description of the incident, the type of information involved in the breach, steps individuals may take to protect themselves, and contact information for the organization responsible. Some states prescribe specific elements or phrasing. Others focus more on clarity and usefulness, and knowing that distinction is going to be very useful because it may come into play with some of the facts you encounter. Let's talk about evolving state breach laws. State breach notification laws continue to change. Some states have expanded what counts as personal information. Others have updated timelines or notice requirements. Recent legislation updates reflect ongoing attention to data security and consumer protection. This evolution means that breach notification laws remain an active area of state regulation. Now, in terms of approach during your studies, when working through a breach-related scenario, it helps to move step by step. Consider what information was involved, whether access was unauthorized, whether misuse is likely, who may need to be notified, what timing or method considerations exist. This structured approach helps keep the analysis calm and manageable. So, in terms of this particular discussion, state data breach notification laws are designed to ensure transparency and protection when personal information is exposed. Although the details vary by state, the core concepts repeat across jurisdictions. So, in terms of preparation for your studies, focusing on definitions, triggers, notice requirements, and timing are crucial. You need to build familiarity with the framework, not in memorizing the individual statutes. Thank you for spending this time with me. I hope you enjoyed this content. If you have any questions, leave a comment below and I'll see you in another video.